Hi, my name is Baldev Bhinder. I work at Blackstone & Gold. I'm the managing director. It's a law firm in Singapore, and we specialize in all things international trade. It's funny to be talking about the URC 522 because not that many people talk about it. Everyone talks about UCP 600, which is the rules associated with letters of credit. For URC 522, that's the rules that dictate collections. I wouldn't say it's a unique rule, but it's something that is not as popular, not as common as the UCP. And what we've seen in the past few years, interestingly, is that we've seen situations where banks have released documents without getting paid by the importer. And that's a pretty catastrophic event for that to happen. The URC, to give you some background, the URC 522 is a set of rules that set the rights and obligations, the standards between a remitting bank sending documents over on behalf of an exporter and a collections bank who's receiving the documents on behalf of the importer. It should be pretty standard. You send a collection letter saying, Mr. Bank, Mr. Collection Bank, do not release the documents until you are paid by the importer. And you incorporate the URC 522 into it. That means that the bank knows it has a certain standard of care it needs to exercise, not to release it without payment or without a duty of care, put it that way, without reasonable care. And in recent times, in the past few years, what we've seen, strangely enough, banks releasing it. And I scratch my head. I wonder why banks are releasing it. I think to myself, could it be maybe the importer is quite big and powerful in that country, has got substantial influence with the bank. It's also coincided in the past few years where there has been US dollar shortages in some parts of the world, South Asia, the Middle East, and currency devaluations. So it could be, I don't know, it could be maybe the importer goes to its bank in its country and say, my friend, I know I'm supposed to pay, but you need to release the documents first so that I can then liquidate the goods, get money, and I can pay you back in that way. And as wrong as it is, that maybe that speech isn't that unattractive to the bank sometimes. It could also be that the bank might not be familiar with URC 522. I know we all work in a world where we think there are certain professional standards, but in some jurisdictions, I think they might not be clear as to what their obligation is under URC 522. It's a good question. I think what I've seen in some cases, the collection letter goes out and it doesn't make any reference to the URC 522. That creates a whole set of problems of its own, but it would go to show that in the mind of the exporter or its bank, they're not even thinking of URC 522. Parties are just operating on a one-on-one contracts basis where I send you a letter on my letterhead or maybe by SWIFT saying don't release the documents, no mention of URC 522. If you go ask banks about URC 522 or people in the trade business, they might not even be that familiar with it. So it is somewhat obscure, and I think that's the case because it hasn't come to prominence. With letters of credit, you have prominence because there is non-compliant presentation. You have to accept it within 5 days. There is that common market practice that everyone knows. With URC 522, I think it's often been the case that what can go wrong? And I think recent history has shown us that some things can go wrong. And I'll tell you what goes wrong. One being that if there is no rule specified into it, there's a question as to what is the bank required to do when it's receiving this letter. Most times when a problem happens, it means the bank has somehow been convinced to release the documents, and it then turns around and its knee-jerk reaction will always be, I haven't accepted this. You've told me not to release, but I haven't accepted this relationship. I haven't accepted these instructions. And I think the law doesn't look upon that quite favorably, that sort of position. I think the law would say, it depends on which country you are naturally, and the law of that country. But typically, if you are acting, when you've got a letter saying don't release, and you act and release it, that is acceptance of that instruction. You are acting in furtherance of that instruction. So you're going to be in trouble. I think most banks, in the cases we've seen, some banks have tried historically to get away from it, saying I'm not going to, or I haven't accepted the instruction. And in that case, I think we'll see the courts or the case law would point to the indication that courts don't look upon that favorably. They would say, no, you are held to it and you are liable for it. And the question is, when you're liable for it, the next question would then be, where? Where are you liable? Think about it. It's a SWIFT message saying 3 or 4 lines. Do not release these documents until you receive payment or until you receive acceptance. Either it's DP or DA, and the bank goes ahead and releases it regardless. What's your recourse as the person who suffered that? Do you go to your bank and say, what's happened? I'm suing you? Or do you go to the collections bank? And I think on a first principles basis, you think you go to the country where the wrong has been done. And that would often be where the collections has been released without authority. And that is the difficult part, because you might be in countries where the court system might not be too favorable to you. So then the issue we come to now is, in a bizarre way, do we have to, or should we consider putting a jurisdiction clause into that SWIFT message saying, these are the instructions. If there's any dispute about this, we will go to court in the UK, we will go to arbitration, we will go to the ICC. What should we do? A jurisdiction clause is basically a clause in any contract that says, should there be a problem, we will get it resolved in a certain court or a certain forum, and it picks that certain court or forum. Many cases have been fought about where that court and forum should be, and people have spent millions of dollars disputing that. It can be a real problem because in international trade, you are across borders. You might feel the wrong as an exporter in, let's say, in Europe, but the collections was done wrongly in Asia. So which part of the world are you going to go and sue? Courts might have different understanding of international trade law, and they might have different processes, how long it would take to get you a result. And some might have different standards of justice. I think it's to be alive to the situation. I think for the longest time, collections is done, it's often done. I think people are just not alive to the fact that there is a chance, however small, of a bank at the receiving end releasing the goods because they've been, for the reasons we spoke about, because they've been convinced by their importer to release, or because they have a poor understanding of what their obligation is in the first place. But once the documents are released, it's a problem, and you're going to end up fighting about it, and you're not even sure where you're going to be fighting about it. So a good lawyer will always say, make it very clear, put it into your collections instruction saying, do A, B, and C, and if there's any issue with A, B, and C, we will go to court to fight about it. I know no one likes hearing that. I appreciate that, because no one's thinking about it going wrong. There's a reason why letters of credit do not have a jurisdiction clause, because it's a payment mechanism, and so you think, of course it's not going to go wrong. And the law provides that if you do have a problem, God forbid, you typically go to where the bank has refused to make payment. And likewise, in this case, it would be where the bank has released the documents. That would be the starting point, but it might not be a favorable starting point for parties.